Jefferson County Court at law number 2 is now in session. The court is in session in 2 cases. First case is cause number 23-CCCR 0372. Second case is cause number 23-CCCR 2508. Both cases are styled the state of Texas versus Ashley Nicole Miro. Miss Miro, is that your full name? Ashley Nicole Miro? Ms. Miro, would you please raise your right hand? Ms. Miro, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Ms. Miro, you may put your hand down. How are you doing, Ms. Miro? You doing okay? That's fine. Ms. Miro, you're represented in your cases by your attorney, Attorney James Macon. Attorney Macon, how are you doing?
Very good.
That's good. The state is represented in these cases by Attorney Erica Porter. Attorney Porter, how are you doing?
I'm doing great.
That's good. Now, Mr. Macon, do you waive a record in Ms. Miro's cases?
Yes, Your Honor.
Ms. Miro, in cause number 23-CCCR 0372, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Ashley Nicole Miro, on or about October 22nd of 2022, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 1.5 or more. Ms. Miro, do you understand what you've been charged with?
Yes.
And to this charge, Ms. Miro, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you are guilty? Yes. Mr. Macon? You have to check the box off for Class A. That one is you have to erase that one. Just Class A.
Fair.
Okay. Ms. Miro, I have before me a document that is titled Misdemeanor Plea Admonishments, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
Now, there's one box that's checked on this document. The box that's checked states that this is a Class A misdemeanor. The range of punishment for a Class A misdemeanor is minimum, it's a term from 0 days to 365 days in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Do you understand the range of punishment for a Class A misdemeanor? On page 2 of the same document, there are 2 sets of initials. One set is your attorney's, the other set is yours. Next to a line that has a box that's checked guilty. Did you place your initials on this document?
Yes.
On page 3 of the same document, I guess, there's a signature above the line that is titled Defendant. Is this your signature?
Yeah.
On the next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document that is titled Misdemeanor Plea Admonishment. That's titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled Defendant? Ms. Miro, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes.
And did you read and understand everything in these documents?
I did.
And is everything in these documents true and correct?
Yes.
To the best of your knowledge? Ms. Miro, are you a citizen of the United States? State, I have before me State's Exhibit Number 1. State, would you like to offer State's Exhibit Number 1 as evidence?
Yes.
Any objections?
No objection to State's one, Your Honor.
No objection. State's Exhibit Number 1 will be admitted. Mr. Macon, you've advised and counseled Ms. Miro, is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. Miro, your attorney, Mr. Macon, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes.
Ms. Miro, I will accept your plea of guilty I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement? And what is that agreement?
In exchange for the defendant's plea of guilty, the state has offered 90 days, Jefferson County Jail with credit for 90 days, time served, tax and retired court company.
Ms. Mira, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not have to serve any more time in the Jefferson County Jail on this case because you've already served 90 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Ms. Mira, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just?
I do.
And do you accept the state's offer?
Yeah.
Ms. Mira, I'll follow the plea bargain agreement that you've entered into with the state. Ms. Mira, we will move to your next case. And your next case is cause number 23 CCCR 2508. And in this case, I also have a document. It hadn't come up yet. So I also have a document in this case that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. And in this information sheet, Ms. Mira, it alleges that you, Ashley Nicole Miro, on or about September 4th of 2023, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 1.5 or more. Ms. Miro, do you understand what you've been charged with? And to this charge, how do you plead? Guilty?
Yep.
Not guilty? Are you pleading guilty? Now, you're pleading guilty freely and voluntarily?
Yeah.
And are you pleading guilty because you are guilty?
Yeah.
Mr. Macon, you need to make the same change on this document.
Thank you.
And Ms. Murray, I have before me in State's Exhibit number 1, the misdemeanor plea admonishment. Do you recognize this document?
Yes.
On page 2 of the same document, there are 2 sets of initials. One set is AM. Did you place your initials on the line next to the box that says check guilty?
Yes.
And on the next page, there's a signature above the line that's titled defendant. Is this your signature?
Yes.
On the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yeah.
And is this your signature on the line that's titled defendant?
Yeah.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have before me the discovery certification. You recognize this document?
Yeah.
And is this your signature on the line that's titled defendant?
Yeah.
Now, Ms. Mira, before you signed and initialed these documents, did your attorney go over these documents with you?
Yeah.
And did you read and understand everything that he wanted?
I-
And is everything in these documents true and correct to the best of your knowledge?
Yeah.
State, would you like to offer State's Exhibit number 1 into evidence? Any
No
objections?
objection to state's one.
No objection. State's Exhibit number 1 will be admitted. And Mr. Macon, you advised and counsel Ms. Muriel. In this case, is there any evidence that she's currently mentally incompetent to stand trial?
No.
And Ms. Muriel, your attorney, Mr. Macon has advised and counseled you in this case. Are you satisfied with his representation in this case?
Yeah.
Has he provided full, effective, and competent legal representation?
Yeah.
Ms. Miro, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is that agreement?
In exchange for the defendant's plea of guilty, the state has offered 60 days in Jefferson County Jail, credit for 60 days, time served, tax and retired court costs.
Ms. Miro, the state is offering that you serve 60 days in the Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail in this case because you've already served 60 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. And that simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Ms. Miro, do you understand the state's offer?
Yeah.
Do you think that the state's offer in your case is fair and just?
Yeah.
And do you accept the state's offer?
I do.
Ms. Miro, I'll follow the plea bargain agreement that you have entered into with the state. Now, this will conclude your cases. Ms. Miro, just have a seat so that the court coordinator could finish the paperwork. When she finished the paperwork, she will ask you to come up to her window. Once you go to a window, that should finalize your case. Once you finalize your case, you'll be able to follow the bailiff. And you have a blessed day. And Mr. Macon, this is your only 2 cases. You're free to go.
Your Honor.
and you have a blessed day.
Ms. Merrill has a felony we're gonna go take care of.
Yeah, just sit in that chair over there, one of those chairs by the wall.
Yeah, she's doing a pay. She gotta give up prints and stuff. Okay, we can get the fenced in for the arraignment. Yeah, I'll sit in the chairs that have with the yellow, black, say they have clipboards by each one. Sir, you took a clipboard from one of those, so you need to move it back. Yeah. Okay. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2 of Jefferson County, Texas. You have been called here today for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. We handle misdemeanor cases in this court. Criminal cases are divided into felonies and misdemeanors. Your felonies are normally referred to as your most serious type of offenses, whereas your misdemeanors are commonly referred to as your petty offenses. It does not mean that they are not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, when I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. And we'll start at the top and work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If they're convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years and a fine that does not exceed $10,000. If they're convicted of a second degree felony, the range of punishment is minimum 2 years to maximum of 20 years and a fine that does not exceed $10,000. Or if they're convicted of a first degree felony, the range of punishment is minimum 5 years to maximum 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned earlier, your case is a misdemeanor case, so you don't have to worry about those type of punishments. Now, your misdemeanor cases are divided into 3 categories, and we'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, they will, the punishment is by fine only. Normally, the fine is cannot exceed $500. Now, normally the Class C misdemeanors are cases that start or originate in the JP court, which is the justice court, or the city court, which is a municipal court. And if that person is convicted in either one of those courts and they appeal their case, then the case comes up to county court at law. And if it comes to county court at law number 2, the range of punishment is the same. Now, however, I mentioned that it's by fine only. However, if an individual fails to pay the fine, or if the fine is converted to a community service and they fail to perform a community service, then the court can issue what is called a KPS pro fine. That basically means that it's a warrant for the person to sit out to pay the fine or sit the fine out in jail. And they receive $100 per day for every day that they sit in jail. That will go toward the fine. Now, the next highest misdemeanor is a Class B misdemeanor. Class B misdemeanor, the range of punishment is 0 days to 180 days in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is 0 days to maximum of 365 days in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that we're going to talk about, at least the first right that we'll talk about, is your right to have an attorney. Now, the paperwork that you have on the clipboard talks about or addresses your right to have an attorney. Now, regarding your right to have an attorney, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number 3, you may represent yourself. Now, if you have enough money to hire an attorney, your case will be reset to give you time to hire that attorney. Reset means you'll be given another court date from this date. So you'll be given another court date to give you time to hire the attorney that you choose to represent you. Now, if you want to have an attorney to represent you, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to you by the court. You would have to fill out a financial questionnaire. The financial questionnaire is the last document on that clipboard. It's titled Jefferson County Affidavit of Indigence. You'd have to fill out the first page of that document and half of the second page of that document. The bottom portion of that document is for the court to sign, and the third page is also for the court to sign. Now, once you fill that document out, then the court will determine whether or not you qualify for a court-appointed attorney. Now, if you want to represent yourself, that's the third option. You would sign a waiver of your right to have an attorney. The waiver should be the second document on that clipboard, and it's titled Jefferson County Affidavit. Well, it's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, you would have to read that document and sign on the line that's titled Defendant and dated today's date. Now, going back to the first document, it says that if you may not speak to a prosecutor about your case unless you first sign a waiver of your right to be represented by an attorney. So if you want to talk to the prosecutor, then the only way you can talk to the prosecutor is if you are representing yourself. If you're not representing yourself, your attorney will talk to the prosecutor on your behalf. Now, if you waive or give up your right to represent an attorney, if you waive or give up your right to have an attorney to represent you, then you'll be allowed to talk to the prosecutor to see whether or not you can settle your case. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, that is, if you waive your right to have an attorney and represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that first document, it states in bold letters, defendant's choice. Mark initials next to only one choice. If your choice is to hire an attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to represent yourself, that is, to waive your right to an attorney and represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date today's date on the line that's titled date, and today's date is February 20th of 2022. Now, as a defendant in a criminal case, you have a right to have a trial by jury. Where those young men are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors on your case. They will listen to all the evidence that's presented. They will listen to all the arguments. They will deliberate, and then they will decide to find you either not guilty or guilty. You also have a right to waive your right to have a trial by jury. Waiving your right to have a trial by jury means that you'll be giving up your right to have a trial by jury, and you will not be having a trial by jury. Now, if you waive your right to have a trial by jury, your case will come before the court in one of 3 ways. One way it will come before the court is by way of a trial. We call that a bench trial. It is a trial by judge only. In essence, you waive your right to have a jury trial, but you still want to go to trial, but you want the judge to be the judge and the jury. So the judge will listen to the evidence, the judge will listen to the arguments, and the judge will decide to find you either not guilty or guilty. Another way that your case will come before the judge is by way of an unagreed plea bargain. Now, the term plea bargain simply means that you and the state have reached an agreement to settle your case. If you have reached an agreement, we call that an agreed plea bargain agreement. If you have not reached a plea bargain agreement, if you have not reached an agreement, we call that an unagreed plea bargain agreement. And either way, it simply means that your case will come before the judge for the judge to decide what your punishment will be. So the judge will decide what your punishment will be in the case of an unagreed plea bargain agreement. Now, if you have a plea bargain agreement, we call that an agreed plea bargain agreement. Your case will come before the judge, and the judge can do one of two things. The judge can accept or reject the plea bargain agreement. So if the judge rejects the plea bargain agreement that you have made with the state, you have a right to withdraw your plea. What that means is this: you have a right to take your plea back. So for example, let's say you and the state have reached a plea bargain agreement for you to serve probation, and it comes before the judge. And the judge says, well, I'm not going to follow that plea bargain agreement. Well, you can say, well, judge, I take my plea back. I'm not going to enter a plea of either guilty or no contest. You have a right to do that if the judge rejects or does not follow the plea bargain agreement. Now, if the judge does follow the plea bargain agreement, and if you decide within 30 days, if you decide that you want to appeal your case, appealing your case means that you want to have a higher court to review your case to see whether or not you've been wrongfully convicted or whether or not the court committed an error by convicting you. We call that an appeal. Then you would have to, if the judge followed the plea bargain agreement, and if you want to appeal, you have to get permission from the judge to appeal your case. And if the judge gives you permission to appeal your case will leave this court and go to the Ninth Court of Appeals, which is right above us on the 3rd floor. They will review your case. Now, they can decide either to grant or deny your appeal. If they grant your appeal, then they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then at that point, you can appeal your case to another court, to a higher court than the Ninth Court of Appeals. You can appeal your case to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas. You will have to file what is called a pro se petition for discretionary review. Pro se means that you'll be representing yourself. Petition means that you'll be petitioning the Texas Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted, or whether or not this court wrongfully convicted you or committed an error by convicting you. Now, the Texas Court of Criminal Appeals can do one or two things. They could either grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty. Or they can send the case back to the Ninth Court of Appeals, or they can send it back down to this court and order this court to give you a whole new trial. Now, if they deny your pro se petition, then at that point, your conviction will stand. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to the court to testify. They sit in that chair right over there to my left, the one with the microphone. We call that the witness stand. They can testify for you or against you. If you represent yourself, you can ask some questions. If you have an attorney, your attorney can ask some questions. We call that either direct examination or cross-examination. You also have a Fifth Amendment right against self-incrimination. And that simply means you have a right not to testify against yourself in your trial. The state of Texas, the government, the district attorney's office cannot force you to testify against yourself if you invoke your Fifth Amendment right against self-incrimination. So if you say, I take the fifth, they cannot force you to testify against yourself. Now, you can waive or give up your Fifth Amendment right against self-incrimination. And by doing so, if you waive or give up your Fifth Amendment right against self-incrimination, you will be testifying in your case. You also have a right to have discovery. Discovery simply means that you have a right to see the evidence that the state has against you or discover the evidence that the state has against you. In essence, you have a right to have access to the evidence that the state will be using or the state have in their file that they'll be using against you in your case. That is, you have a right to see witness statements, your statements. You have a right to see reports, lab reports, police reports. You have a right to see video recordings. You have a right to listen to audio recordings. You also, if there's some telephone calls, or if there are any instruments that they have, you have a right to have access to those. So you have a right to have access to the evidence that the state will be having or will be using against you, and we call that discovery. Now, everyone that's here this morning for arraignment, you have been arrested and you bonded out of jail. You're either out of jail because you bonded out on what is called a cash bond, which means you paid the full amount of the bond to get out of jail, or you're out of jail on a surety bond. In essence, you have a bondsman, you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on a PR bond or a personal recognizance bond, which means you did not have to pay any money to get out of jail. You were released under your own personal recognizance with a promise to appear here in court. Now, every day that you spent in jail, whether it was 1 minute, that's considered a day. Every day that you spent in jail, that jail time can be used as credit toward your punishment. And what I mean by that is this. For example, let's say you spent 5 days in jail. And let's say you and the state have reached a plea bargaining agreement where you will serve 5 days in jail. Well, that simply means you will not have to serve any more time in jail because the 5 days that you spent in jail has already been served. And so you'll be given credit for the time that you've already served. So you won't have to spend any more time in jail. Now, if the state is offering you 7 days in jail and you spend 5 days in jail, that means we'll take the 5 from 7 and then leaves 2. You would have to serve 2 more days in jail. Now, every day that you spent in jail can also be credited as time toward the payment of your fine and court costs. Every day that you spend in jail, you get $100 a day that will go toward your fine and court costs. So if you spend 5 days in jail, that's $500 that will go toward your fine and court costs. So if you and the state have reached a plea bargaining agreement for you to pay fine and court costs of $500, and you spend 5 days in jail, you will not have to pay $500. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. That simply means that you will not have to pay it because the time that you spent in jail has already paid it off. Now, if the state is offering you fine and court costs of $700 and you spend 5 days in jail, which is $500, we'll take $500 from the $700 and leave $200 left for you to pay. Now, you'll be required to pay the $200 on the day that you dispose of your case, if you cannot pay the $200, then we can require that you pay off the $200 over a period of time. We call that a payment plan, or you pay it off in installments, in monthly installments until it's paid off. And for some individuals, you may not even have the income to pay it off in installments. That's not a problem either, because the court can convert your fine and court costs to community service. When I say the court, the judge can convert it to community service if the court finds that you are indigent. And every 1 hour community service that you perform, $12.50 will be credited towards your fine and court costs. So for example, if you work 8 hours of community service, that's $100 that will go towards your fine and court costs. So if you owe $200, you have to work 16 hours, community service hours, which is like 2 days, and you will pay off the fine and court costs. Now, Jefferson County has a program for first-time offenders. If you haven't been in trouble before, it's your first time getting in trouble, Jefferson County has a program that is called pretrial diversion. And with that program, they will dismiss your case. And once you complete the program, you can get it expunged from your record, meaning that it can be erased, deleted, or wiped off from your criminal record like it never happened. Now, in order to qualify for that program, as I mentioned, that's to be your first time getting in trouble. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest, and you have to have an attorney to assist you to make the application to get into the program. And if you get into the program, the case is dismissed, you complete the program, you can get it wiped off of your criminal record, so you won't have this on your criminal record. If you're a veteran of any one of the branches of the United States military, Jefferson County also, when I'm talking about when I use the term Jefferson County, I'm talking about the district attorney's office. But Jefferson County has a program that is called Veterans Court. It's for veterans only. So if you are a veteran of any one of the branches of the United States military, you can qualify for Veterans Court. And with that program, what they'll do, you get into the program, complete the program, they'll dismiss your case, and you can get it, you can get what is called a non-disclosure. And what a non-disclosure is, it means that we cannot disclose to the general public the fact that you were on probation for this offense. So that's what it's called. It's kind of like having your record sealed, but the general public cannot have access to it. Now, I'm using the term the general public. The government can have access to it, but not the general public, okay? Now, if you're interested in any one of those programs, just let us know, and we can give you the information that you need so that you can see if you qualify for those programs. Now, this court, County Court at Law Number 2, has a program that is called the CSI program. CSI stands for Community Safety Initiative. That is a program that I started within the first 100 days of taking office. And the program was started in March of 2017. With that program, we have partnerships with various agencies. And the program is designed to address the issue of what we call recidivism. Recidivism is when it's a term where it basically refers to people committing crimes over and over. And so the way we address recidivism is through the CSI program. And with this program, as I mentioned earlier, we have partnership with various agencies. And one of the agencies that we have a partnership with is Spindletop Center. Spindletop is our local mental health center in this region of Texas. And Spindletop, we have some people from Spindletop who will come to you a little in a few minutes, and they're going to tell you more about the Spindletop program. But the Spindletop program, the way it was designed, they will do a private interview with you. They will do an assessment. They can develop a treatment plan, either outpatient, inpatient, to address whatever mental health needs that you have. When I use the term mental health needs, you don't have to be incompetent or insane to participate in the program. The program is designed for individuals who might suffer from anxiety, depression, or any other host of mental illnesses. Spindletop has the expertise to address those mental problems that individuals have. If you have issues with alcohol or drugs, well, Spindletop has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. Our local alcohol and drug counselor has a program that is called OZAR. OZAR stands for Outreach, Screening, and Referrals, or Assessment and Referrals. With those programs, they will conduct a screening. They will do an assessment, and they can develop a treatment plan, either outpatient or inpatient. You can refer to outpatient or inpatient treatment. If you are unemployed and do not have a job, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of those areas that you select, they will assist you at getting a job in the area that you're trained in. If you have not graduated from high school and you would like to get a GED, a graduate equivalent diploma, then CICE has a GED program that can assist you at getting your GED. Now, all of these programs that I've just mentioned are free. It does not cost you anything but a little time. And I like to say in this court, we do not just give time, we take our time. That simply means that we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people, we can make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. And I like to say that when you come to county court at law number 2, we do not have court as usual, we have unusual court. And it's not because we're different, it's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in the lives of the individuals that comes before this court, we will also make a difference in their home. And if we make a difference in their home, then we'll also make a difference in the community. Why? Because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know. We have some brochures that we can give to you. And as I mentioned to you earlier, we have some individuals from Spindletop who's going to come before you and tell you more about this program that Spindletop has to offer. We have Deputy Hinton and Chris. They're going to come and tell you more about the Spindletop program.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission with the sheriff's department. This is my coworker here, Chris. Now, Chris is a qualified mental health professional with Spindletop. The reason we are both here this morning is because the judge cares about every single person who comes before the meeting. The judge has found, and what statistics prove, is those who have legal issues come around have mental health needs, such as use disorders, or sometimes just the lack of human resources to help you in a particular situation.
As George said, a lot of times that looks like anxiety and depression, right? Things that we've all dealt with at some point in our lives, and some things that we will deal with some point later that the court system doesn't necessarily make easier. where it says inpatient, outpatient, we're just talking resources. No one's gonna send anyone anywhere. If you want to go through an assessment or interview, we can, but we can also just follow, if you guys ever need that. When you came through, we handed out this form. This function is a baseline for the consent form. The only person who received this is me. The only person who will reach out to is me. And then we have your feedback. It's not gonna be a robocall situation. It's not gonna be one of those times where I just blow up your phone. But if you reach back out, even if you just say, anything, I can keep talking to you. I can keep working with you. If there's something you need, as I said, inpatient, outpatient, but we don't really have inpatient in this area. But if you need information on inpatient resources outside of this area, we can help with that. There's a lot of things that we have access to that we can direct you towards, and we can also talk you through, because there's a lot of really great community resources that are well funded. And that can be anything, that can be financial resources, education, work, anything like that. They're well funded, but they're not well advertised, and sometimes you can just find you and you can get that much done.
Maybe this is your first time to be here, maybe it's your 10th time to be here, there's still hope. In fact, what we're offering you today has the ability to change your life, but we're gonna need something from you. And you share that need with us, and Chris will explain how you can do that very privately.
So, as I said, this is a baseline of the consent form, right? It's protected, your state law for information is protected. If you can put down what you need, or what you want to talk about, even just filling it out, that will help me, because I can look for things that maybe can help in advance, or I can call or text, and we can just talk. A lot of times, one of the big community resources that's missing is just support. There's a lot of social support that we don't really get very often, especially not within the court system. We come here and it's not a moment anybody really wants to be in. But if we can make it something better, if we can meet some other meeting outside of here during this process, we can make it productive, we can make it work. You all showed up. We all know you work hard for yourself because you came here. There's many people who missed support today. You showed up, you took the time to be here, and now we want to make it productive.
Before you leave here today, I also want to give you this flyer on the back. It tells you some of the advantages of participating on the front. It also has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number.
So the big thing about that number, I looked at it in Jefferson County, but we do also recognize a lot of people in important Jefferson County that are not anywhere close to here, right? That's the first resource we can give you. We are not limited depending on where you live. We're not limited if you're here for yourself or as a dependent, or if you need information for somebody you care about. That resource is active almost statewide. If you're not from Texas, if you're from Louisiana, we can find something out for you. You just gotta let us know. But you can call that one at 6 a.m. on Christmas morning. Anywhere in Texas pretty much has cell service. Maybe it won't work over in like the Big Bend area, but nothing works in the Big Bend area. You can call that number and they will get you help immediately. They will talk to you or help you figure out what resources are around you. They will just be there. There are plenty of other resources like that that we get you access to. You just gotta let us know what you need. That's literally the only thing we're here for, is to help.
So in just a little bit, court's going to go into recess. When it does, we'll be able to come out there and visit with you, answer any questions you have. Pick up those documents from the office and leave this out there.
One more thing, on the bottom of the document, it does have an option to speak today privately. I know the court will be moving a little bit faster, because I know that it started a little bit later yet. If you do select yes on there, there's a chance that you may not be able to go back and talk, but that I will call you today if you put down yes. So this is not gonna be anything that interrupts your day or takes away time from you. You have control of this. You know, if you have just the kind that work best or needs to contact you, if you'll write it down, next to your contact choice, I will do my best to contact you at that time. This is supposed to be something that is easy for you, because a lot of times asking for help or getting information is not.
Thank you for your time. Thank you, Your Honor.
You're welcome. Okay, ladies and gentlemen, the paperwork that you have on the clipboard, we're going to pick that paperwork up from you. And so if you need some help filling out the paperwork, just please let us know. We have our court personnel who will be happy to help you. Now, it's going to take us a few minutes to pick up the paperwork from you. So in the meantime, if you need to use the restroom, there are 2 restrooms right outside in the hall. The men's restroom is in front of County Court at Law number 3, which is right next door, and across the hall in front of The 172nd District Court is the women's restroom. Now, do not leave the courthouse, because if you leave the courthouse and call your name, if you do not answer, your bond can be forfeited, and if your bond is forfeited, a warrant will be issued for your arrest. So at this time, the court is going to go into recess. And if you need some help filling out the paperwork, just let us know by raising your hand. At this time, the court will be in recess.
Right here.
Need to get this to him. You gonna stand in front of the bench? I need, this is cause number 23CCCR 2210. Case is style, the state of Texas versus Israel. Josiah Hanson. Mr. Hanson, is that your full name?
Yes.
How are you doing, Mr. Hanson?
Doing good.
Mr. Hanson, would you please raise your right hand? Mr. Hanson, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Hanson, you may put your hand down. How are you doing, Mr. Hanson?
Mhm.
Okay, Mr. Hanson, I have before me a document that is titled Standard Bond Conditions in County Court Law Number 2. The bailiff just handed you the same document. I'm going to go over this document with you. And it reads as follows. Following the return of a criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 states, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Condition number 4 does not apply because it only applies in a DWI case or driving while intoxicated case. Your case is not a DWI case. Your case is assault, family violence. However, condition number 5 does apply. Condition number 5 states as follows. The defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by the Texas Penal Code Section 1.07, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Hanson, if you violate any one of these conditions, your bond will be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Okay. Just have a seat in that first chair, and the court coordinator is going to reset your case.
Okay, thank you.
All right, you have a blessed day. We just reset that. Jefferson County Court at Law number 2 is back in session. The court is in session in 5 cases. They are cause numbers M332598, cause number M332600, cause number 24CCCR 0004, cause number 24CCCR 0003, and cause number 24CCCR 0460. All 3 cases, all 5 cases are styled the state of Texas versus Andrew Lackey or Andrew Lee Lackey. Mr. Lackey, is that your full name?
Yes, sir.
Okay, Mr. Lackey, would you please raise your right hand? Mr. Lackey, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Lackey, you may put your hand down. Mr. Lackey, you represented in your cases by, well, you represented in 3 of these cases by your attorney, Ryan Matuska. Attorney Matuska, how are you doing?
Morning, Your Honor.
Good morning. Now, Mr. Lackey, you have before you a document that is titled Standard Bond Conditions in County Court at Law number 2. You see that document?
Yes, sir.
I'm going to go over these bond conditions with you, and it reads as follows. Following return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, defendant shall submit to testing for drugs and alcohol anytime as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that
Yes,
condition?
sir.
Condition number 4 does not apply. Condition number 5 does apply. Condition number 5 says that the defendant shall wear a global position monitoring system device at the defendant's expense with written verification being submitted to the court within, that'll be 3 days after you're released from jail. Understand that?
Yes, sir.
Now, what else I'm going to add on here is that that GPS is you'll be required to get that GPS before you are released from jail. So upon release from jail, you need to have that GPS.
Yes, sir.
Okay. Condition number 6 states that the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer defined by section 1.07 of Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
And give me that his conditions back. Condition number 7, I'm gonna add, you're gonna have to attend AANA meetings twice a week, and you're gonna provide proof of that, of your attendance to the court every time that you come to court.
Yes, sir.
Okay? Now, do you understand these conditions?
Yes, sir.
Now, if you violate any one of these conditions, your bond will be revoked and you'll be placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Linda. I'll make a copy of this back page. Okay, once you get these bond conditions, you can follow the bailiff, and the magistrate is gonna set your bond at the jail.
Judge, on the 3 days, since he's required to have
I'm saying within 3 days after he's released.
with the GPS device.
That's what I'm talking
If
about.
he's required to have it installed in the jail, is he still required to submit proof 3 days?
No, when he's released, upon his release from jail, he's gonna have that GPS. And then, once he's released, I'm sure he's gonna get it installed and be released at the same time. Then within 3 days, he have to provide proof. He can give it to
You
you,
can do that to me.
and then you can provide.
The verification, that should be. Johnny's or. One right there.
You can staple this together,
Not even-
and you can get it back to him.
I mean, you have to call Johnson. I'll tell you. Okay.
Yeah, you can staple it. Just want to make sure I have the paperwork. Right. There you go. There you go. You can follow the bill. Jefferson County Code, law number 2 is back in session. Notice in session, back in session with the Rayma document. When I call your name, please come before the bench. First case is called number 23 CCCR 2652. Case is style of state of Texas versus Robert Scott. So, Mr. Scott, your full name is Robert Lee Scott Jr. I need some other conditions. Mr. Scott, would you please raise your right hand? Scott, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Mr. Scott, you may put your hand down. How are you doing, Mr. Scott? That's good. Mr. Scott, I have before me a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled defendant? Or are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yeah.
Okay. Now, before you signed and initialed this document, did you read the document? Okay. And did you understand what you read?
Yeah.
And is everything in these documents true and correct?
Yes.
To the best of your knowledge?
Yes.
Okay. Mr. Scott, I read your answers, and your case is going to be reset to give you an opportunity to hire an attorney. But before your case is reset, I'm gonna need to give you some bond conditions. And you'll be able to get a copy of these bond conditions from the court coordinator before you leave. And the bond conditions are as follows. The title is Standard Bond Conditions in County Court Law number 2, following the return of a criminal information in County Court Law number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state or any other state or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test of drugs and alcohol when directed to do so by the court, or B, submit to a test of drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
Now, condition number 3 does not apply, and condition number 4 does not apply because 4 is only applies in the DWI case. Now, condition number 5 does apply, and it states as follows. Defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer, as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Scott, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest, and you'll be arrested and placed in the Jefferson County Jail. You're gonna have a seat in that first chair by the wall, and then when the court coordinator is ready for you, she's gonna give you your reset date and your bond conditions. You'll be free to go, and you have a blessed day. So have a seat in that first chair. Jesus Fuentes. All right, you good. Yeah. Yes, it's. Mr. With this, just have a seat right there. We'll call you back up. Next case is cause number 23CCCR 2250. Case of style of state of Texas versus Brent J. Thrasher. Mr. Thrasher, your full name is Brent J. Thrasher. Okay, Mr. Thrasher, I have two cases. Those cases are cause numbers 23CCCR 2250 and cause number 23CCCR 2456. Both cases are style of state of Texas versus Brent J. Thrasher. Mr. Thrasher, would you please raise your right hand? Mr. Thrasher, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Thrasher, you may put your hand down. Mr. Thrasher, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line stating you want to waive your right to an attorney
Yes, sir.
and represent yourself? And I have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Correct.
Mr. Thrasher, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Well, now that you say the guilty plea,
No, it's not a guilty plea. It's just saying it's a waiver for purposes of entering a guilty plea or proceeding to trial. That's just the title. Now, did you read these documents? Okay, let me do this here. I'm gonna get these documents back to you. You can have a seat. He can have a seat and go read the documents.
thank you.
Okay. Next case is Krista Smith. Krista Janae Smith. Ms. Smith, your full name is Krista Janae Smith. Ms. Smith, would you please raise your right hand? Ms. Smith, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Smith, you may put your hand down. How are you doing, Ms. Smith? You can relax. I just need to go over these documents with you. Ms. Smith, I have two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Are these your initials on the line that state you like to apply for court-appointed attorney? Okay. Next document is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of this same document, There's a signature above the line that is titled Defendant Signature. Is this your signature? Ms. Smith, before you sign and initial these documents, did you read the documents? And did you understand what you read?
The rest was explained.
Okay, so someone explained it to you, so you understood what was explained? Now, is everything in these documents true and correct to the best of your knowledge? Okay. Ms. Smith, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that's appointed to represent you in this case is Attorney William Wilkerson. Attorney Wilkerson will be given information to contact you. You will also be given information to contact him. Our court coordinator is going to give you that information. Once you get the information from the court coordinator, you'll be free to go. And you have a blessed day. Please have a seat in that first chair by the wall. Yes.
I wanted to ask you about the GED program as well.
Okay, give me some papers for the program at Lamar, CICE. Okay, okay. That's the program that they have, and you can call that number.
First offenders program?
Okay, you can talk to your attorney about that. That's the pretrial diversion program. Yeah, okay. There you go. Just have a seat in that first chair. And once she calls your name, once you finish, you'll be free to go and you have a blessed day. Jakia Johnson White. Ms. White, your full name is that Jakia Johnson White?
Yeah.
Ms. Johnson, would you please raise your right hand? Ms. Johnson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Johnson, you may put your hand down. How are you doing, Ms. Johnson? Okay. Now, Ms. Johnson, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature online as titled Defendant? And are these your initials online the state you'd like to apply for a court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes.
On page 2 of this same document, there are a set of initials. Well, there's a signature above the line. It's titled Defendant Signature. Is that your signature?
Yes.
Now, Ms. Johnson, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, it is.
Ms. Johnson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Attorney Boudreaux will be given information to contact you, and you will also be given information to contact him. Our court coordinator is going to give you that information. Once you get the information from the court coordinator, you're free to go, and you have a blessed day. Ms. Johnson, just, okay. Okay, yeah, the clerk will give it to you.
Which one should we use?
CICE. That the information from Lamar, you can give me another one.
Yeah, you can.
Okay. You can come on up. Court is back in session in two cases, clause number 23 CCCR 2250 and clause number 23 CCCR 2456. Both cases are styled state of Texas versus Brent J. Thrasher. Again, Mr. Thrasher, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Now, Mr. Thrasher, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line as titled defendant? Are these your initials on the line stating that you would like to waive your right to an attorney and represent yourself? I also have another document that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding in the Trial. You recognize this document? And is this your signature on the line as titled defendant? Now, Mr. Thrasher, before you sign and initial these documents, or after you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Thrasher, your case, just have a seat where you were sitting and someone from the district attorney's office will come out and talk to you. Mr. Scott, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Scott, you may put your hand down. How are you doing, Mr. Scott?
Right.
I'm doing fine. Thanks for asking, Mr. Scott. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line as titled defendant?
Yeah.
Are these your initials on the line stating that you'd like to apply for court appointed attorney?
Yeah.
I also have a document that is titled Jefferson County Affidavit Industry. You recognize this document? And on page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature? Mr. Scott, before you sign and initial all of these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Scott, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of the court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Langston Adams. Attorney Adams will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day.
Thank you.
Thank you. Jesus Fuente. Mr. Fuente, would you please raise your right hand? Mr. Fuente, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Okay.
Mr. Fuente, you may put your hand down. How are you doing, Mr. Fuente?
Good.
That's good. Mr. Fuente, I have before me a document that's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant? Are these your initials, are these your initials on the line and state you'd like to have your case reset to hire your own attorney?
Yes, sir.
Also, now, before you sign and initial that document, did you read the document?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in that document true and correct to the best of your knowledge? Okay. Now, Mr. Fuente, your case is going to be reset, give you an opportunity to hire your own attorney, but before your case is reset, I need to give you some bond conditions. Ms. Mosby, and these bond conditions. Okay, I'm gonna go over these bond conditions with you, and it reads as follows. Standard bond conditions in County Code Law number 2. Following the return of a criminal information in County Code Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant herein, named herein, are ordered subject to the additional condition. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. You understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense. The defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
And condition number 4 does not apply because that only applies in the DWI case. This is not a DWI case, but condition number 5 and 6 does apply. Condition number 5 on the next page states that the defendant shall wear a global positioning monitoring system device at the defendant's expense with written verification being submitted to the court within 3 days. Do you understand that condition?
Wait, what happened? We're number 5?
Number 5, the defendant shall wear a global positioning monitoring system, commonly referred to as GPS, system device at the defendant's expense with written verification being submitted to the court within 3 days. Do you understand that condition?
Yes, sir.
And condition number 6, the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer defined by section 1.07 of Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Fuente, if you violate any one of these conditions, your bond will be revoked, and if your bond is revoked, the warrant will be issued for your arrest, and you'll be placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay, so you're gonna have a seat, first chair by the wall, wait for your name to be called. Once your name is called, you'll go to the window, and once you finish at the window, you're free to go and you have a blessed day. We need to get Miss Oh, okay. Oh. Jefferson County Code Law number 2 is back in session. The code is in session. And calls number 23 CCCR 2570, case of style of state of Texas versus Arturo Alejandro Salvidra. We have Mr. Salvidra, who is in court. We also have Miss Cynthia Renteria, who is translator. Ms. Renteria, would you please raise your right hand? Ms. Renteria, do you swear to interpret Spanish to English and English to Spanish to help you God?
Yes,
Okay. How you doing, Ms. Renteria?
I'm good, Jacqueline.
I'm doing fine. Thanks for asking. Ms. Renteria, ask Mr. Salvidra if his full name is Arturo Alejandro Salvidra.
Ese es su nombre completo, Saavedra Arturo Alejandro.
Arturo Alejandro.
Saavedra. Yes, sir.
Okay. Tell him to raise his right hand.
Alce su mano derecha.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Usted,
So help you God.
usted jura decir la verdad, todo la verdad, so que lo ayude Dios. Yes.
You may put your hand down.
Podemos dar su mano.
Okay. How are you doing, Mr. Salvidra?
¿Cómo está, señor Saavedra? Good.
Okay. Mr. Salvidra, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
¿Usted reconoce ese documento? Yes.
Is this your signature on the line that's titled defendant?
¿Esa es su firma? Yes.
And are these your initials on the line stating you want to apply for court-appointed attorney?
Esas sus iniciales diciendo que quiere aplicar para una corte que le apunte un abogado. Yes.
I also have another document that's titled Jefferson County Affidavit of Indigence.
Ese,
Go ahead on.
ese documento también está ante el juez.
Do you recognize this document?
Si lo reconoce. Yes.
Is this your signature on the line that's titled Defendant Signature?
¿Esa es su firma? Yes.
Now, Mr. Salvidra, before you sign and initial these documents, did someone go over these documents with you in Spanish?
¿Alguien le explicó esos documentos en español antes que usted los firmara?
Sí.
Yes.
And did you understand what they went over?
¿Y si entendió lo que dicen los documentos?
Sí.
Yes.
And is everything in these documents true and correct to the best of your knowledge?
¿Esa información que está en esos documentos es correcto? Yes.
Okay, Mr. Savidra, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a co- bueno,
El juez revisó los documentos y en cuanto a él decide que sí califica para que la corte le apunte un abogado.
and the attorney that's will be appointed to represent you, Attorney Charles Ross.
Y el abogado que lo va a representar es el señor Charles Rojas.
Your case is going to be reset by our court coordinator. Once you get your reset, you're free to go and you have a blessed day.
Va a ver a la señora, ella le va a dar la próxima fecha para venir a corte. Abogado, pase buen día.
Next case is cause number 23-CCCR 2614, case of style of state of Texas versus Christina Figueroa. Ask Ms. Figueroa if her name is Christina Figueroa.
¿Ese es su nombre, Cristina Figueroa? Yes.
Um, ask Ms. Okay, raise your right
Alza su
hand.
mano derecha.
Ms. Figueroa, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Señora Figueroa, ¿usted declara decir la verdad, toda la verdad, que se la ayude Dios? Sí. Yes.
Okay, you may put your hand down. Ms. Figueroa, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
¿Reconoce ese documento? Yes.
Is this your signature on the line that's titled Defendant?
¿Esa es su firma? Yes.
Or are these your initials on the line that state you'd like to apply for court-appointed attorney?
Esos son sus iniciales diciendo que quiere ver si califica para que la corte le apunte un abogado. Yes.
I have another document that's titled Jefferson County Affidavit of Indians. Do you recognize this document?
¿Reconoce ese documento? Yes.
On page 2 of this same document, there's a signature above the line that's titled Defendant's Signature. Is this your signature?
¿Esa es su firma? Yes.
Ms. Figueroa, before you signed and initialed these documents, did you read the did someone go over these documents with you in Spanish?
Antes de firmar esos documentos y estar de acuerdo con ellos, ¿alguien le explicó en español esos documentos? Sí. Yes.
And did you understand everything that they went over?
¿Y si entendió todo lo que le explicaron? Sí, para aplicar con el abogado. Yes, to apply for a court appointed.
And is everything in these documents true and correct to the best of your knowledge?
¿Es cierto lo que están en esos documentos? Yes.
Okay, Ms. Figueroa, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. The attorney that will be appointed to represent you is Attorney Charles Rojas. Ms. Figueroa, Mr. Rojas, you could tell her who.
Calificó para que la corte le apunte un abogado y entonces la corte le va a apuntar un abogado y el abogado se llama Charles Rojas. Sí. She just asked if he spoke Spanish, so I
Yes.
said yes.
And he'll contact you,
Él te va a contactar a ti
and our court coordinator will give you the information for you to contact him.
y la señora ahorita te va a dar una fecha para que lo contactes tú también. El número de teléfono va a estar en esa hoja. Okay, ¿cuándo? Pronto. Eso ahorita se lo va a dar. She
Okay?
just asked when was she getting.
I know, I heard pronto, so that means me.
No puede tomar asiento y ahorita ya le llaman.
All right, have a blessed day.
Thank you.
Thank you, Ms. Renteria.
Yes.
You have a blessed day.
Thank you as well.
Did Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M327050, case of style state of Texas versus Stephen Mark Sadler. Mr. Sadler is represented in his case by attorney Wright Kimler. Mr. Sadler is not present, however, Mr. Kimler is present. Mr. Kimler filed a motion to quash the indictment, or should be quash the information in this case. And the state is present. Well, first of all, Mr. Kimler, how are you doing?
I'm well, Your Honor, thank you.
That's good. The state is present with Assistant District Attorney Eric Porter. Attorney Porter, how are you doing?
Much better now.
Now, Mr. Kimler, this is your motion. You'd like to proceed?
Your Honor, the motion itself is self-explanatory. It's predicated on the sacred right that we all have to engage in free expression as codified or incorporated, more accurately to say, in the First Amendment to the federal Constitution, and applied to the states under the 14th Amendment. Also in the state constitution, I think that the state constitutional provision to be cited in the motion, I don't recall it offhand, but also the state constitutional guarantee for freedom of expression. Obviously, when the state seeks to prescribe any type of speech, it's looked upon rather severely and strictly by the courts. And of course, in the criminal context, even more so. In this case, the defendant was charged with, I believe, harassment and language. There's no type
Communication.
of communications harassment. There's no type of physical act alleged other than verbiage, other than the speech. So what we have is the state attempting to criminally proscribe and punish speech, and they're allowed to do that, but only in very limited context. Looking at the case itself, just looking at the language of the statute, I would say that there's problems with the statute itself, aside from how it's applied in this particular case to Mr. Sadler. The case that I would refer to, the case law, of course, the outstanding case law is Brandenburg v. Ohio. And I guess what we might have is the fighting words exception to the First Amendment. And of course, the state can obviously prescribe and punish conduct or speech that by its very nature under an objective standard amounts to the so-called fighting words exception, where it's the type of words that a reasonable and ordinary person would consider incite them to violence that is immediately precipitating violence. It's immediate, imminent violence. It's the type of speech that promotes imminent breach of the peace. And of course, that enjoys no First Amendment protection. The speech as alleged, and I don't think the statute addresses that. So I would say that the statute itself is probably constitutionally infirm that Mr. Sadler is charged under. But secondly, even assuming that there is some validity in the way the statute is written, which I don't think that it is, the particular speech that they've alleged that Mr. Sadler has engaged in factually doesn't rise to that standard. It is protected speech, and because somebody subjectively perceives that to be either a threat or of a harassing nature, that's not sufficient to render it illegal under the Constitution and the constitutional protections that we have to engage in free speech. The speech that Mr. Sadler is alleged to have engaged in isn't of the type that it would be seen to immediately incite a breach of peace. It's so-called fighting words exception. And for that reason, we ask that this information be quashed.
Say.
Okay. Your Honor, we're looking at the four corners of the information is valid. So I saw going through his motion and all of the subsections 1, 2, 3, 4, 5. Defense alleges that in 1, the instrument does not allege a violation of Texas law. It does in fact allege a violation of Texas law. It alleges that Mr. Sadler committed the offense of harassment. 42.07 Texas Penal Code outlines the offense of harassment. Section 2 goes into the amendments, 4th, 5th, I think you mentioned the 5th, the 14th Amendment of the Federal Constitution, which we're not here to try the case. We're only here to look at the four corners of the information. And Section 3, well, you went on in section 2 to describe reasonable notice. He was given reasonable notice as defined in this information. It actually outlines the date, the act, and what he did, and what the harassment in and of itself, it describes it. So it is particular, it is specific, and it falls underneath 42.07. It also is valid on its face. There's nothing wrong with the four corners of this information. Therefore, we're asking for you to deny his motion, the defense motion to quash.
Yeah, it should be, I'm sorry, I'm looking at the motion to quash. I cited the Fifth Amendment. It should be the First and 14th Amendment. So I'd make an oral motion to amend the motion to quash to, under Section 3, to say that it violates the First and 14th Amendments to the federal Constitution and not the Fifth and 14th. It should be First and 14th Amendments. I think I have the right, I think I have the right section under the Texas Constitution. I'm used to writing the Fifth instead of first. I always cite the First Amendment of the criminal case. But it should be the first. So I move to amend the motion, the written motion.
You have any objections?
Of course, it's made orally and in court during the hearing. So I'm objecting based on that, like a notice.
Okay, your objection sustained.
Well, let me just urge on the record then, that it's obviously I'm arguing First Amendment grounds here in the hearing to purposes of the record.
Okay,
For the court to rule.
I mean, the state could have, the state, actually is unprepared in that they weren't aware that you was gonna argue the First Amendment. They were prepared for you arguing the Fifth and the 14th Amendment.
Well, I'll have to re-urge it at trial then, which, I mean, I don't want to wait, I'm not, maybe,
I understand.
Urge it at trial, it's the first. Yeah, I'm urging it now as an objection, just on the record, that it's the first, not the first and 14th, but the Fifth and 14th.
Okay,
Court wants to consider that.
so at this time, the court is gonna take this matter under advisement. Okay. So that will conclude this hearing.
But I think Article 1, Section 19 is coextensive with the First Amendment. The state.
Article 1, Section 19, Texas Constitution.
Yeah, I think that's the state. protection.
Okay, all right,
All
all right, thank you. Okay, this will conclude the motion to quash and the court's arraignment docket on today's date of January 20th of 2024 in County Court at 11-2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. You're excused.